is number 11 not included in your number 10? It seems to be somewhat of a...
I don't have strong feelings on that as far as number 11.
So you're withdrawing that based on the
Yeah, sure.
number 10?
That'd be fine.
And number 12, tell me about
For the indictment, of course, in order to properly draft the indictment, and the statute basically outlined that a particular offense may happen in more than one way, or the elements of a particular offense may happen in more than one way, that you're required to charge them then conjunctive, even though the statute outlines them in the disjunctive. You get to trial, even though you charge them in the conjunctive, you only have to prove either one. And that's what that outlines. So there's a number of matters like that in the indictment where, for example, here's one that just came to mind.
We don't have the 12, I'm sorry.
I gave that to you yesterday.
Yesterday was served separately.
Right, yesterday. Sure.
Close about to make a copy of 12. What was your question?
The specific charges that he thought that applied to?
And that's going to be my question too, which,
So I have to go through each one of them.
Explain to each other the difference. Right.
here is my thought. I'm going to give them a chance to look at this too. That for me to consider giving this, I think it's only going to be helpful to a jury to identify what counts those are in. You're able to do that.
Yeah. This is the charge that we've done or like that repeatedly before. I didn't think it's anything new at all. For example, an armed robbery, and there may have been one before that, but an armed robbery, count 9, it indicates that the defendant did with intent to commit theft, taking an amount of lawful United States currency, cell phones, and the Chevrolet Street motor vehicle property of Jadon Brooks from the person and immediate presence of Jadon Brooks. It would be, actually, the statute said from the person or the immediate presence of Jadon Brooks. But in order to properly frame the indictment, we have to use the word "and" in order to provide notice to the defendant, even though the statute used the word "or."
I understand.
I know,
but
what I'm saying is that would be one there, and then they were asking what ones, but there's a number of others in that. But I'm not certain you would have to identify the counts, but you could. I mean, I think.
Do you have your copy of that now?
Yes, sir.
Y'all want to talk about it a minute? I hear that from you.
I don't object.
All right. I'll,
Well, you know, I tell you what, I don't really know what this is. I object for the record, and stand on the position. I just object to it, whatever, however you rule on it.
well, I need to know the basis of your objection.
Yeah, it's confusing and unnecessary, and, or, what the difference is. I mean, I told you what I've done.
Are there any other charges that?
Do I need to address that at all in any way?
You can.
Regardless of whether Mr. Hood is not gonna do this or do that, the jury may look in the jury room and look at the word in the indictment and see the word "and" in the conjunctive and come to some understanding that despite your instruction when it came to armed robbery or kidnapping or whatever, hijacking a motor vehicle or some of the other offenses, that even though your instruction said "or," since they have, alleged "and" in the indictment, and we're required to, prove every essential element alleged in the indictment, they may come to the understanding that if they find one and don't find the other, then in that event, they'd be authorized to not find sufficient evidence along those lines, which would be contrary to the law. That's why this charge is important, irrespective of whether the defendant's gonna say that or not say that. They'd be the ones in the jury room saying that, and you'd be charging one thing, and the indictment basically says it in the conjunctive because we're required to basically do that in order to give the defendant appropriate notice in the indictment of what he's charged with. If we use the word "or," then there would be issues that could be raised along those lines when that happens. So I think this is appropriate. It's been done, and I think it's an appropriate term.
I'll give 12. I don't know where I'll put it, but. Anything else? Additional requests from the state?
We have call it a request, but maybe not, but in regard to 35, Judge, we had some language that we drafted. I won't call it necessarily states 13, but although it's in the form of a request, and we could label it 13 if need be. As far as the definition of possession of a firearm by convicted felon. Yeah, okay.
objection from the defense as to replacing page 35, the charges, possession of firearm of convicted felon, with the state's request to charge 13?
Your Honor, I think when we were going through this, because we had talked about that you were going to give a clean copy to the jury that didn't have the headings, and I think on a couple of them, we talked about striking things that referred to the code section. I didn't tell Mr. Hood to raise this, I just had assumed that once the actual clean copy came out, that things that said like this code section or whatever would not be in there anymore. And so that's why I hadn't told him to mention it, because several are like that. You know, it seems this just restates the pattern instruction without the words like the code section and that refers to the code.
Give me a
My request doesn't, I don't think our request has the word code section.
That's what I'm saying, is that, you know, I don't think we have any objection to it. It says pretty much the same. It's just, and the assumption I had made is that for anything that was like that, it would take on, you know, an insignificant change when you actually presented it to the jury. And so, other than that, that's why I don't.
That is my
Okay.
intent to do that.
Okay.
The code section references titles, pattern charge numbers.
Yes, sir. Okay.
If there's cases, some of these charges have, you know, cases cited under, all that will be removed.
Okay. All right.
And actually, I believe 35 was charging an offense that we did not charge. It was charging 131, it was set out 131, 1611, 131B1, which had the additional elements of who attempts to purchase or obtain transfer of certificate. It has those additional, that's not what we charged in count 5 and in the later count.
But you did charge on.
54, count 54, we just simply said, if that's a firearm, that's a certain handgun after we convicted the felon offense of armed robbery. All that set out 1611, 131B. Just simply, the firearm after every convicted of felon. It doesn't involve an extra element of actually attempting to purchase or obtain transfer of a firearm, which is what was set out on page 35. That's a different offense altogether.
So back to my question.
Yes.
Any objection?
No.
This is your charge, so this is what you're asking for, so I will remove 35 and replace it with state's 13.
I think the defendant needs to respond to that. I think it's Herbert.
No objection, no objection, Judge.
I think it's Herbert responded.
Well, no objection for the record.
All right, thank you. All right, Mr. Hood, any other request to charge for you that I've not addressed?
Yes, sir, Your Honor. I would, as for Officer Buddy Preston, I would request a lesser included charge on voluntary manslaughter. You know, yesterday, my testimony yesterday, put in evidence before the jury that formed a question of fact for them to decide regarding whether I acted as the result of a sudden violent or irresistible passion caused by serious provocation. Therefore, it is appropriate to charge them that they have the option to return verdict on voluntary manslaughter rather than murder, if they so chooses. Because this is a political case, Judge, it'd be hard for me to believe that a jury may just acquit me for political reasons. You know, they might be feel like if a yes or no, hey man, we might not want to do it, but we got to do it. So this would give them something else, a lesson, because hey, I didn't even know I was going to see it that day. Didn't even know it was going to happen. So, you know, that's why I would tell you, I got to take the responsibility of the role I played in this. So I'm not just asking, hey, just let me go free on this, because, you know, I did play a role in this and I did do it. But, you know, in my heart, and I don't feel like it was malice. You know, I'm not just asking them, I'm not asking to let me go scot free on it.
you have a voluntary manslaughter charge?
I mean, I haven't prepared my, I mean, way to do that, Your Honor. I don't have an office here or a computer.
Could you add that in your language as far as what the Officer Christian charge? Could you just add that?
We're just asking for the statute.
The statute.
16-5-2.
Anything else you want to tell me about that?
No, I just feel like that's appropriate because, you know, I'm not asking to be let go scot-free on it.
And specifically, what was the evidence that you're claiming that supports voluntary manslaughter?
Well, number one, my brother missed the road. If the man had turned down the road, I would have never seen him. Number two.
I just didn't understand. Say that one more time.
Number one, my brother missed the road with Sycamore Drive. He testified to it, and I did. If the man had just made the road, I would have never seen the police anywhere. I would have been behind him. And this police shooting incident would have never happened. Number two is the history that I had with Tony Howard. If it had been another officer who gonna follow the protocol, the police shooting incident would have never happened. Number three, I'm running down the road with Officer Christian coming up the road in his car. I didn't even know I was gonna see him that day. So it couldn't have been malice. How could I malice murder somebody that I don't even know him? I ain't never seen him my whole life. Never talked to him. Never had a problem with him. It couldn't have been malice. So malice murder would have forethought. How could I have forethought to kill Officer Christian? I ain't never seen him my whole life. Don't know that about him. And then I think that'll be, you know, pretty much fair. Because it'd be hard, again, for me to believe, hey, the jury, man, you done killed the police, whether you meant to or not. And we got the option to, is guilty or not guilty. That might give them something else. That's another avenue. I ain't asked to be let go scot-free on it.
Anything else? Mr. Baldwin?
Judge, we would strongly object to that, not only was there no request made in writing by the defendant, there's been no request made by the defendant back for any charges. But there is absolutely no basis to charge voluntary manslaughter in regard to the death of Buddy Christian, Officer Buddy Christian. There's no evidence of any kind of provocation. In fact, the law, the person is not justified in using force if that person is attempting to commit, is committing, or is fleeing after commission or attempting commission of a felony. Certainly in regard to Officer Christian, even if he was doing something that he somehow suggests here, he would have been perfectly authorized as an officer to act in that way one way or another. But anything he's describing in any way, in no way, is sufficient evidence to constitute any sort of matter upon which you would be authorized to charge voluntary manslaughter. There is absolutely no basis in any way in the evidence here to suggest that, you know. And I would strongly object to that. Again, there's been no written request made.
I may judge. If provocation comes from Officer Howard, and this where it come from. He even told me I didn't even pull out a gun. He the one come through his car one. He admitted he the first one in history, and Addy Clark kind of do that mess. And it come from the history. That where the provocation come from, Officer Howard. That would cause his fear. I'm shooting out of fear. It wasn't Officer Christian personally. It was the circumstances. It happened so fast. How could I afford to kill Mr. Christian and to have that fast and don't know it? That's why we had several officers come in here so they wouldn't even did it the way Tony Howard done it. It was maybe 2 to 3 to maybe 4 seconds to have, Judge. Wow! Just like that. So it couldn't have been no folks though. And the provocation come from Tony Howard and that history I had with him. He even admitted that he come through that one and grabbed me. While he was sitting in his car. I ain't never seen it. The gun didn't come out till he died. I was trying to just get away. I didn't know Officer Christian was coming up the street in the car. It was, wow. It just happened so fast. So it couldn't have been no forethought or no malice murder. Judge, I had more, it was fear. I had 8 more bullets in the car and the gun. Madam heard what it kept on shooting off the Christian. What, boom. And I turned myself in, and I done told him I done done it. It can't be malice. You read my letter on to his family the first night. I've been apologizing for him the whole time. And if he want to talk about, look how many stuff he brought up at the end, Judge. He brought all type witnesses in, all type evidence in that he hadn't even filed for. We all hear about the truth at the end of the day. I'm not asking to get off scot-free. It was fear, Judge. What it said, with 28 yards, running 28 yards, it was that provocation. It was that bad history. It wasn't Officer Christian. And that's a question for the jury to decide, not the prosecutor.
He was not even authorized to have a firearm.
Well, if his witness hasn't, that's what the justification come from.
I've heard that. Yes. I'm not going to charge voluntary manslaughter as a lesser included. All right. What else? We have verdict form. Any objections to the proposed verdict form?
What you say, Judge Bishop?
Verdict form. You will notice that I think the state had prepared one, but we modified that somewhat to treat some of the other the false imprisonment charges, make it clear so as to avoid inconsistent verdict.
I think we have inconsistent verdicts in criminal cases, and I don't think that would be inconsistent. Someone would be found guilty of false imprisonment and kidnapping. I don't.
So you're objecting to this verdict?
I don't. charge, Judge, would, if they're charged with all three. I mean, they're charged with, they're charged with kidnapping as well as false imprisonment. And there would not be, that would not be an inconsistent verdict to have somebody found guilty of false imprisonment and kidnapping at all. It would just simply merge for sentencing at that time if they're found guilty of both.
What if they're found not guilty of false imprisonment, not guilty of false imprisonment?
There's no inconsistent verdicts in criminal cases at all, and that would not be inconsistent at all in doing that, Judge.
So if found guilty of kidnapping, but not guilty of false imprisonment,
Well, I mean, this will deal with that, but there's no inconsistent verdicts in criminal matters. And so consequently,
I'm trying to-
that would not be, you know, but it's kidnapping, of course, is not the lesser included offense of false imprisonment, but still, I don't, that's basically saying that you only consider false imprisonment if they find them not guilty of kidnapping, which is not, it should be just guilty, not guilty of each.
On each charge.
Offense, yes, sir. We shouldn't have anything about lesser included offenses or indicate that false imprisonment is a lesser included offense. This isn't, it's not like he's charged with kidnapping and then someone requested false imprisonment as a lesser included offense. Those are all alleged in the indictment. You know, the kidnapping and the false imprisonment as far as each of the hostages there. So they could clearly be convicted of both counts, in which event it's sentencing. You know, the false imprisonment would merge into kidnapping. You wouldn't have a separate punishment for false imprisonment. So I don't think that's appropriate, because it's not like he's just charged with kidnapping and then they're asking for a lesser included offense, or one party's asking for a lesser included offense of false imprisonment. In that event, you wouldn't actually have a separate count that they would consider. So I don't think that's a correct verdict form in doing that.
You want to be heard on that, Mr. Hood?
No, sir. Our position, we have no objection for us. Verdict form.
We'll go back to the stage one. As far as that, but I am gonna add, I think there was something, I did remove, the bold print and some of it, and I think I've added the language under the election of guilty, not guilty, so we can be clear.
I thought your charge probably covers that in my mind, and just putting a blank there and have them just fill in what the.
Well, my experience has been it doesn't necessarily cover. Do you object to putting guilty, not guilty?
I'm sorry, Judge.
Do you object to putting guilty, not guilty on the verdict?
I've never seen it done, I guess, and so the only ones I've seen is basically just have a blank for them to fill in the verdict. So I think it would be clear that they're basically, based on your instructions, you know, decide whether guilty or not guilty.
Yeah, we have no objection to guilty, not guilty, as long as they write it in, because they might circle the wrong one.
Right, it is.
They're not supposed to circle anything. Maybe that gives the impression they're supposed to circle
Well,
something.
all I was telling Mr. Hood was that he wanted just to say that we would like the instructions to the jury to be very clear that they're to write it in, not circle, because we're, you know, the circle goes over both words and you don't know
Exactly.
what they chose, so.
That's why frankly, I think it'd be best not to have that. My experience.
Any objection to removing it?
No.
I'll remove it.
They gonna write it in, though, right?
Oh, yes.
Okay.
On each count. Anything else we need to take up?
Well, we were looking at the statements, I think. they're the ones that really put in the statement. In addition, the defendant testified to pretty much what was said in the statement. And they're the way, it was their statement pretty much. That's what they wanted in. Those portions, and certainly was done by agreement. I'm not certain, all of a sudden, then we would have a charge in there to indicate that, well, you need to really, consider this. And based on what was set forth in the pattern instructions about, hey, if it's, pretty much the defendant is agreeing to do that or putting that in, or they're the ones doing it, then why would that be charged at all? I don't see that I understand that in any way. And then what was being put in was what he insisted on in both instances. So,
Judge, I object what he's saying. I like the lane to be kept in. That's my position on that. And I just like to state that for the record, how we move on.
I'm gonna leave in 16 through 23.
you're working on the aggravated assault, or what do you?
We're gonna work on that. Let's, I'll, 31. Let me take it in order. I've got, the next one I've got is 31, malice murder defined. There was some question about that. And I believe it was,
I think the question had to do with the request of voluntary manslaughter, am I right?
I believe so.
I think that's what the question, that's what the
And
question.
that's been dealt with. So 31 is. Gonna make some changes to 34, felony murder. We'll have that. Before you start. We've replaced 35 with the state's request, page 35 with state's request to charge 13. And then you requested some combination, I believe, on the aggravated assault. Is that correct, Steve?
I would, with a combination or something, separation, if we've got some of them that are, you didn't have aggravated assault with a peace officer with a deadly weapon that's charged anywhere. And my suggestion, if you're separating out different types of aggravated assault, we have aggravated assault with intent to rob, aggravated assault with intent to murder, put a peace officer, and so forth, that you probably ought to have something that's aggravated assault with a deadly weapon and define that. And then aggravated assault with any object that when you intend against the person is likely to result in, serious injury, and that charge to deal with that. And then aggravated assault upon a peace officer with a deadly weapon, aggravated assault upon a peace officer with intent to murder. You were going to combine those two, I think, trying to put those together, 39 and 40, the aggravated assault. And then you would have aggravated assault with intent to rob, aggravated assault with intent to murder, and you would define those separately maybe. But, and then, like you indicate, you're going to put aggravated assault with intent to rob before the robbery charges. So, in any event, if we're separating them out, I suggest we separate all of them out, or we somehow put in there, this is definitely an aggravated assault. You commit aggravated assault, you assault someone with a deadly weapon, or assault someone with an object that has been used against them, or you assault someone with intent to murder, or you assault someone with intent to rob. And then go into defining them. If you're going to combine them, then
I don't intend to combine them. I intend to keep them separate.
Sure.
And I'm telling you that because we'll have to work on that, but that's for your
Yes.
closing argument purposes. I don't know if that would make any difference really in closing argument, but that would be what I plan to do, is keep them separate. Except we are going to look to combine 39 and 40.
And on 36, that's the one that I had a question about, because the way it sets out, a person commits offense of aggravated assault, and that person assaults another with a deadly weapon, or with any object that would use offense against a person is likely to result in serious bodily injury. I don't know whether the way it's worded there, it may imply that the deadly weapon has to be one that is likely to result in serious bodily injury. That's not the way we understand that to be. So I don't know whether it ought to be a person commits offense of aggravated when that person assaults another with a deadly weapon, or that person assaults another with any object that would use offense against a person is likely to result in serious bodily injury. The device or instrument was never alleged in the indictment. Actually does result was never alleged, it's just likely language. So
You're asking to strike divisive or instrument.
device or instrument, and then, or actually does language as well. And if you're gonna insert something, you insert something, after deadly weapon, or you insert, it would be or when that person assaults another with any object. So it's clear that it's two different matters. You assault with a deadly weapon, or you assault somebody with an object. That will use offense against a person likely to result in serious bodily injury. So, then again, I think you have to have aggravated assault with a deadly weapon. But a peace officer with a deadly weapon, we have not defined that within there, and that's what the offensive charge in the United. But that should be added in the charges. We have aggravated assault on a peace officer with intent to murder, but we don't have aggravated assault on a peace officer with a deadly weapon charge set forth in the charges.
Be part of modifying page 39.
Anything else on that?
Well, the modified, if we were modifying that, how would that be modified? You're modifying 39.
I don't know if I sit down and start doing it.
Okay. With a deadly weapon or with intent to murder, would that be what it would be, I guess?
Commits aggravated assault with a deadly weapon, or commits aggravated assault with intent to murder. We're in the principle that says, as I previously defined it, we'll adjust that to simply specify the types of aggravated assault. So it wasn't a deadly weapon, one with intent to murder.
We would have it here at the end here. Aggravated assault on a peace officer, those who commit aggravated assault, but also while that officer is engaged in or counted as one official duty with a deadly weapon or with intent to murder.
Right.
And then you would indicate the firearm with a deadly weapon. So, okay.
Anything else on that?
Yes, sir.
Should. So, no.
No, sir.
Anything else we need to take up before we decide about when to come, we convene and have the jury here and begin summation? Stay.
Yes, sir. Did you add in, my request on the justification, the first part of 16-320?
Oh, that. I am going to stay with a pattern charge. I'm not going to add anything additional to that.
Well, Your Honor, with all respect, that's what the statute says, though.
I understand that.
And it says any crime, that, you know, that language could be misleading to a specific crime, and that's what the statute said. Is that what we doing throughout the whole case? This is what the statute, so it's not like, it's not like we asking you to do something wrong. 16-320 is what the statute said, it's open up, the first sentence here, the first paragraph, the fact that a person conduct is justified is a defense to prosecution for any crime based upon the conduct. If you don't add that in there, that's not a justification defense you get now. You get a self-defense defense, what you're doing. My defense was justification. It was 16-320. That's what I alleged in my motion.
I understand, I'm given the charge as you have it.
Well, that's not a charge of justification. Yeah, yes, I'm gonna stand up as for a continuing justice, but that's not a justification defense, Your Honor, what you give me. You give me a self-defense, 16-3, you doing 16-321, and that wasn't my defense. My defense was 16-320, justification that was defense. It's both of them. The justification, that's how you include self-defense. It says right there, when a person conduct justified under code section 16-321, 16-323, 16-324, 16-325, 16-326, it comes from 16-320, y'all. That's why I did it. I just didn't say 16-321. I said 16-320 justification, which includes 16-321, 16-323, 16-324, 16-325. So that's
Your objection's noted.
okay.
Anything else?
Thank you. I don't know anything about charges.
All right, I'll have the jury here at 2 o'clock, to start, summations.